Hello and welcome to the Patent Agent Preparation Series. My name is Priggya Arora. I am an intellectual property lawyer and a patent agent. So this, as you all know, that this is Patent Agent Examination Preparation Series. In this video, we'll discuss about surrender of patent, revocation and compulsory licensing. So let me share my screen and directly proceed with the provisions. So let's begin by surrender of patent. So surrender of patent is nothing but a patentee wants to surrender its patent. So that is called as surrender of patents. So because these sections are relatively very easy to understand, I'll not go into the detail, but I'll explain the basic concepts which are required for you to understand. So surrender of patents is given in section 63, and it generally means that a patentee at any time, by giving notice in prescribed manner to the controller, offer to surrender his patent. So whenever the patentee wants that he does not want to proceed with this patent anymore, so the patentee can surrender the patent. Always remember, surrender happens only when the patent is granted, and we are discussing the post-grant processes now. That means when the patent is granted, what all can happen. That's why surrender, revocation, compulsory licensing, infringement, all these concept comes after the patent is granted. They are not the concept of patent grant process. They happen after the patent is granted. So surrender also once the patent is granted, but the patentee does not want to proceed with the patent anymore, they can file for surrender. And for example, someone wants to oppose that surrender. There could be a scenario that the patent is licensed to somebody and that person wants to oppose the surrender of patent. In that case, what will happen is surrender can be opposed in form 14. So any opposition for surrender of patent comes under form 14, and the relevant rules are rule 57 to 63 and 87. So these rules are the same that we studied during opposition process. So I'm not repeating them again, but for surrender of patents, if anybody opposes the surrender of patents, the same process is followed. So next comes the revocation of patents. Again, here I'll try to explain the concepts and you can study them in detail so that you know which provision states what. But the important sections here are section 64, 65 and 66, which say 64 is related to revocation of patent, 65 is related to revocation or amendment when the patent relates to atomic energy, and 66 is revocation of patent in public interest. So these are some provisions of revocation of patents, but let us understand when can revocation be filed. So again, it is the process which is followed post grant. So for example, post grant, any interested person wants to cancel a patent. So in that case, that interested person can file a revocation. So if the revocation proceeds and it proceeds successfully, the patent will get cancelled. So this is the concept of revocation, and there are certain stages and there are certain ways by which the patent can be revoked, which are mentioned in section 64, 65, 66, and one of the important section is section 85 as well. So let us try to understand what are the scenarios which are related to patent revocation, and I'll suggest give the reading of these section once, but understand the scenarios because those are the most important part. So first is section 64. So section 64 says, subject to provisions contained in this act, a patent, whether granted before or after commencement of this act, may be revoked on a petition of any person interested or of the central government by the appellate board, or on a counterclaim in suit for infringement for a patent by the High Court, or on any of the following grounds. So let us try to understand when can it be revoked. It can be revoked first by on a petition by any person interested. So you have to understand, like I told in the previous section, mostly whenever patent has been granted and post grant process takes place. For example, post grant opposition takes place. So who can do a post grant opposition? Any interested person can do a post grant opposition. Similarly, who can file a patent revocation? Any person interested can file a patent revocation. It's not written that any person can file for a patent revocation. Only any person interested can do it. Who else can do it? Central government can do it, or on a counter claim in suit for infringement of patent by the High Court. So what is counter claim in a suit for infringement? Though I'll explain this in infringement as well, but let us try to understand the scenario. For example, I hold a patent and the person XYZ is infringing on my rights. So what I will do, I'll file a suit for infringement on person XYZ. So what is the best defense for person XYZ? Person XYZ will say, Priggya's patent is invalid. Therefore, Priggya's patent should be cancelled. So XYZ is putting a counter claim on me saying that my patent is invalid. So whenever this is the scenario, the counterclaim in a suit for infringement goes to the High Court, and in that case, the High Court may revoke my patent. So this is the scenario which is explained in section 64. So first was section 64(1), where we have these 3 points. Then we have section 64(4), that on a petition filed by the central government by the High Court under certain circumstances, applicant without any reasonable cause failed to comply with the request of central government. So for example, section 99 says that there are certain scenarios where government can use the invention for their own purpose. Or what is government purpose? So government has this exception, and now government has imposed this exception onto our rights, and government says on these grounds we want to use your invention, and you say no, you cannot use it on these grounds, then the central government can file for patent revocation. Next we have section 65, which is specifically related to atomic energy. So we have read that inventions related to atomic energy should not be given a patent because that subject matter is non-patentable subject matter under section 4. Still, in case anybody gets a patent on an invention which relates to atomic energy, it can be revoked under section 65. Then we have section 66, which is by the central government in public interest. So for example, there is any invention which is called mischief to the state and or which is prejudicial to the public. In that case also, patent revocation can be filed under section 66. Then we have section 85. Again, here you'll have to understand the scenario. Why? Because though title of this section says by the controller for non-working, it doesn't mean that patent can be revoked for non-working, because the scenario or the text inside this section speaks of differently. It says that 2 years have expired since the grant of first compulsory license and conditions of compulsory license is not met. We'll study compulsory license just now, but it is important to understand here is for a period of first 3 years from date of grant, a compulsory license cannot be granted. Still, when a compulsory license has been granted, 2 years is expired since the grant of first compulsory license, and after grant of first compulsory license, the conditions of compulsory license is not met. For example, there is one of the conditions that your patent application is not being worked in India. This could be one of the conditions based on which a compulsory license is granted. So for a period of first 3 years, patent was not worked in India. That's why the government granted a compulsory license. For next 2 years, even after granting a compulsory license, the patent still not worked in India. and conditions for granting compulsory license was not met. In that case, the controller can revoke the patent, saying that it is a revocation under non-working. So non-working only happens when a compulsory license is granted and 2 years have been elapsed and still the patent is not worked in India. So these are certain scenarios for patent revocation, and these scenarios are important. So if you read the sections, you'll get to know what is written where, because I'm not going into the details of the section because they are too long and they're easy to understand relatively. If you understand the concept, you'll understand these sections very, very well. Next, we have compulsory license. So it against the title of these provisions says working of patent, compulsory licenses and revocation. And section 83 to 94 come under these sections, under these headings. So important sections are section 83 to 94, but most relevant section under this chapter is section 83, which is general principles applicable to working of patented application. Then section 84, very, very important for understanding compulsory licenses. Then section 90, which is terms and conditions of compulsory license. Then section 91, it is also an important section which is related to licensing of related patents. Then we have section 92, which is special provision for compulsory license on notification by government. Then we have 92A, which is compulsory license for export of patented pharmaceutical products in India in certain exceptional circumstances. Then we have section 94, termination of compulsory license. And then we have rule 96 and form 17 and form 21. So form 17 is for application of compulsory license and for 21 is for termination of compulsory license. So let me explain the concept of compulsory license or general principles associated with patents and based on which grounds the compulsory license can be granted. So see section 83. So section 83 says general principles applicable to working of patented application. So this section gives us gist of why a person should be given a patent, for what reasons the person should be given a patent, and for what reasons the person should not be given a patent. So if you read this section, you will find things like patent should be granted to encourage inventions. It should not be merely to enable patentees to enjoy monopoly. So the idea is not to enjoy monopoly. The idea is to encourage inventions. The idea is to promote technological innovation and to transfer and disseminate technology. So these all are ideas or general principles which are applicable for working of patented invention. So when a compulsory license is given, if you go to section 84, which is a very important section, and I would suggest read this section in detail, I think twice, because it includes a lot of concepts, but I'm explaining the concepts and then you can read your section yourself and it will become very easy to understand. So first is a compulsory license is a license which is granted to a third party to strike balance between public interest and legitimate interest of patent owner. So what does this mean? This means that, for example, I am a patent owner and there is public which is involved and I have been granted a patent on something. So what government will do? The government, in order to balance my right and public interest, may grant a compulsory license to a third party XYZ and say, because Priggya was unable to fulfill the requirements of public, XYZ can take a license from Priggya and fulfill legitimate interest of public. So here it does not mean that this license is free of cost. A lot of people think because it is a compulsory license, it is free of cost. No, that does not happen. a compulsory licensee is given the royalty fee. So whenever there is a compulsory license between two parties, royalty fee is given. That's why the person is able to earn money from that as well. That's why it is said that it is a means to manage or to balance public interest and legitimate interest of the patent owner. Then why a compulsory license is granted? To prevent abuses of exclusive rights. So, for example, I get monopoly in the market and I charge unreasonably highly from the general public. So, what I am doing, I am abusing the use of my exclusive rights. So, to prevent that abuse, a compulsory license can be granted. And according to compulsory license, so these are just general principle like which are applicable to compulsory license. The ultimate beneficiary should be public. The public is the main thing. Like the whole idea about patent is the public gets to use new technologies. Therefore, the ultimate beneficiary should be the public. And always remember, a compulsory license is non-exclusive and non-transferable. What are these terms? So non-exclusive means if, for example, a person A or a company A is granted a compulsory license, that does not mean that company B, C, D cannot be granted a compulsory license. No, this will not happen. Compulsory license is non-exclusive. If one person can get it, other parties can also get that license. And it is non-transferable. What does that mean? For example, the company A gets a compulsory license. Company A cannot give it to company B. Company A cannot give it to company C. It is non-transferable. Once it is given to a company, that company can practice the compulsory license. That company cannot transfer it to anybody else. So these are the general principles which are applicable to compulsory license. Now, most important thing which is in compulsory license, be it objective, subjective, this question would be there that what are the conditions of getting a compulsory license, and there are three conditions which are mentioned in section 84 as well. And these are reasonable requirements of public with respect to the patented inventions have not been satisfied. That is, reasonable requirements of public are not met. Then the patented invention is not available to public at reasonably affordable price. That means I'm charging exuberantly high and the invention is not available to public at reasonably affordable price. And then the patented invention is not worked in territory of India. Like even after getting a grant, I'm not working the patented invention. But always remember that a compulsory license can only be given after expiration of 3 years from grant of patent. So before 3 years, we cannot get, even if these grounds are applicable, then also we cannot get. We can get only after 3 years. And here also, because like I said, mostly if it is a post grant process, the term any person interested is used. So who can apply for a compulsory license? Any person interested can apply for a compulsory license. When can a person apply for a compulsory license? At any time after expiration of 3 years from date of grant of patent, any person interested can apply for compulsory license provided any of these three grounds are met. So these grounds are important. Reasonable requirements of public are not being met. Patented invention is not worked in India, or patented invention is not available to the public at reasonably affordable price. So in this section, like I told you, it is important. So it is explained what are reasonable requirements of public with respect to patented invention have not been satisfied. So what does this mean? It is given in clause 7. So I think you'll have to do a fair reading of this only, because even if I explain, you'll not be able to remember these terms unless you read it once. But still, for the sake of clarity, I'll try to read it once for you. So this is subsection 7, and it says, for the purpose of this chapter, the reasonable requirements of public shall be deemed not to have been satisfied by reason of refusal of patentee to grant a license or licenses on reasonable terms. So this says, like, when does reasonable requirements of public will not be met? So it would not be met due to refusal of grant of patent, grant of license. These things happen. And what are these things? Trade or industry is prejudiced. Demand for patented article has not been met to adequate extent. The market for export of patent manufactured in India is not being developed, or development of commercial activities in India is prejudiced. So these are the 4 conditions which are mentioned here in subsection 7A, and then we have 1, 2, 3, 4. Next is imposition of conditions by the patentee. So for example, the patentee is imposing extra conditions while licensing the product. So clause B and clause C fall under this category, and I'll give you some examples to explain this. So for example, I am the patent holder, and a person XYZ comes to me for a license, normal license, not a compulsory license. So whenever I am giving the license to person XYZ, I try to enforce extra conditions. Those conditions could be in the form of exclusive grant back license. Those conditions could be in the form of coercive package license. So what does this mean? For example, that person XYZ, I say that whenever you develop further on this technology, you will give an exclusive license to me, and you cannot use the further developments yourself or give the license of that further development to anybody else. So this is the extra conditions which I'm trying to impose, and whenever I try to impose extra conditions, it becomes ground of compulsory license, because it will fall under reasonable requirements of public with respect to patent inventions are not being satisfied. The another example of coercive package licenses, for example, I try to bundle up my license with several other things. I have a patent on one technology, but I say, if you want to take this license from me, you'll have to take these several other licenses as well. Otherwise, I'll not give license. So this is some extra condition which I'm trying to impose. So whenever this is the case, it will become a ground for a compulsory license, and XYZ can go and ask for a compulsory license saying that Priggya is trying to put extra conditions on while licensing this product to me. So this falls under the category of impositions of conditions by the patentee. Next, we have non-working of patent in India, and it is mentioned in clause G, which says, if the patented invention is not being worked in territory of India on a commercial scale to an adequate extent, or is not being worked to the fullest extent that is reasonably practicable. So if the invention which is patented is not being worked to whatever level it could have been worked, or it could have been reasonably practicable, if it is not being worked, it can become a ground for compulsory license. And next we have clause E, which says working of patented invention in territory of India is prevented by importation from abroad. So this means you have a patent in India, but then working of it on a commercial scale is being hindered or prevented by importation from a patented article from abroad. So if that is the case, then also it can become ground for compulsory license. Why? Because India is not able to earn any profits from that technology. And if India is not able to earn any profits from technology, or people of India is not able to use that technology, all we are doing is importing the stuff from outside, and people are not able to use it in India, or it is being hindered. So if that is the case, it can become a ground for compulsory license. And if you closely read clause 3, subclause 3, it says other person against whom the patentee is not taking or has not taken proceedings for infringement. That means infringement is happening, but again, patentee is not taking any measures to prevent that. So if we are not able to get any profits, the India is not able to get any profits, or people of India is not able to use the technology, then it can become ground for revocation. So it can become grounds of compulsory license. So these are important elements of compulsory license, and you should read these provisions at least once, because a subjective question can come. And the most important element in compulsory license is these three elements, like reasonable requirements of public are not being met, patented invention is not available to public at reasonably affordable price, and patented invention is not worked in India. You should absolutely remember these by heart, because at least one question will come from this section. So yeah, I think this was all for which explanation was required. But again, you'll have to read these provisions yourself. And if you have any questions related to compulsory license, revocation, surrender, or anything else in the Patent Act, please feel free to ask, and I'll be happy to answer. Thank you.